Hey everyone, and welcome to today's video. We've got a follow-up on a case I've been keeping an eye on involving a self-proclaimed sovereign citizen from Lakes, Forest Parks, someone whose courtroom behavior has been so baffling that I'm genuinely shocked he hasn't been held in contempt or taken into custody after walking out of a hearing mid-session. How he's managed to avoid consequences this long is anyone's guess. But what I do have is a growing collection of clips documenting every bit of his courtroom chaos. If you haven't seen the earlier installments, a link should be popping up at the top so you can get caught up on this ongoing disaster. Now, before we jump in, I know a lot of you have been asking about parts 3 and 4 of the series covering the sovereign citizen who tried to take me to court and lost spectacularly. Don't worry, they're still on the way. I've been traveling recently and didn't want to rush those episodes or put out anything less than my best work. But now that I'm home for a full week before heading off to Dublin, I finally have the uninterrupted time needed to finish them.
Mr. Schuster's case, Ms. McDonald?
Well, Mr. Schuster, just to give Your Honor a little bit of background on this one, Mr. Schuster is representing himself. The court has previously gone through the waiver of right to counsel. When we were here, I believe the last hearing, Mr. Schuster gave an indication that he wanted to resolve these matters. So I have drafted a plea form with the city's offer on it. I just am not sure how to get it to him. I can certainly send it to him in the chat. I just don't know if he has the ability to download that and sign it if in that respect. So,
hi, ma'am. How are you today?
Hold on a second. So let's preliminary matter. This is Jonathan Schuster, 4A0525748. So it sounds like Ms. McDonald's trying to get you some documents, Mr. Schuster.
Yeah, so for the record, I reserve all rights and retain them. I am making a special visitation for the matters pertaining to Jonathan Schuster, for I am the beneficiary. I had mailed out some paperwork over to the prosecution as well as submitted it to the court. Have you received those, ma'am?
So I've received 2 motions from Mr. Schuster. Have you?
Yeah, the 2 motions as well as the affidavit, as well as the certified copy of the. So you got that paperwork? Were you able to read it?
I have 2 motions. One was, both were received today.
Right. You should have received an affidavit as well.
I don't see any affidavits.
It's on the back.
The affidavit was received at the same time that the motions were submitted, and so.
and I don't know that we've received anything. I'm checking with my office right now, but I don't see anything in our files.
I emailed to Ms. McDonald this morning.
You did? I'm sorry, what, Madam Clerk?
I emailed to you a copy of the first motion to dismiss and the affidavit of proof, it's called.
Yep, there was a motion for dismissal as well as a motion for show cause, as well as the affidavits.
Hold on, Mr. Schuster.
And so those were sent over.
Hold on, Mr. Schuster.
As well as submitted to the court.
Mr. Schuster, hold on a second. Ms. McDonald's getting caught up. I do have your affidavit.
Yeah, I just wanted to make sure I said that. Thank you.
Don't worry, you'll have plenty of opportunities to speak as this hearing goes on. But one thing you really should have picked up by now is how to handle basic communication like an adult. Let one person finish talking before you jump in and talk over them. Not only is it disrespectful, but it also puts a spotlight on your complete inability to follow simple procedures. Every time you interrupt, you're practically announcing to the entire courtroom that you didn't come prepared. You don't understand what's happening, and you're determined to make things harder for yourself. If you just wait your turn, listen, and respond when appropriate, you might actually come across as someone trying to participate instead of someone trying to derail the process. But since patience seems to be your toughest challenge, this hearing is about to become a long lesson in why listening first is always the smarter. Move.clip to hold on, there's no regardless here. You just finished acknowledging that a previous judge has already reviewed your so-called subject matter jurisdiction motions and denied them. That means this isn't new territory, and you're not presenting anything the court hasn't already dealt with. This judge isn't required to reopen an issue that's already been decided, and she certainly doesn't have to spend time re-explaining something you should already understand.
Clerk, did you send that to my email or did you send it to the office email? Because I don't have anything from you today. Except the orders from Mr. Bailey Garrison and the borrow out information from Mr. Goodwin.
Okay, if you need time to get that, that's fine. I just require that due process is, that we.
Okay, hold on, Mr. Schuster. There's going to be plenty of time for you to talk.
Yes. Thank you. Also, the prosecution, I've never received anything from you as well, but there is an email on for contact information, so you can send that over via email if you have anything to send to me.
We sent you discovery at both addresses that you gave to the court. So they were physical copies because there's digital evidence as well.
Well, I just have never received anything from you.
Well, it went out to your mail, so I don't know what to tell you about that.
Did you check,
Yeah.
Mr. Schuster?
I mean, I haven't received anything.
That's not my question. My question is, are you checking your mail regularly?
Oh, I definitely look out for mail regularly.
Okay, and does the court have your current address?
So he updated it, Your Honor. We actually had this situation issue a couple of weeks ago, or actually almost a month ago, where we had sent out full discovery to the defendant, and then he indicated that that wasn't his address. So we sent out another packet of full discovery to him to the address that he updated. Let's see, the one on Kenyon Street.
2318 California Avenue.
You gave us on January 27, 600 Southwest Kenyon Street, apartment G201 in Seattle.
You're talking about on January 27th when the judge denied subject matter jurisdiction that day?
So the address that you gave to the court on January 27th was the 600 Southwest Kenyon Street, apartment G201. So
the same day that
that was the
Mr. Schuster,
denied subject matter jurisdiction?
Mr. Schuster, is that the address you gave on January 27th?
I don't recall, but I do have, somewhere she can send it to. So
Well,
that
we're not going to play the game of you updating your address every court date so that you can avoid service of discovery.
I'm just letting you know that I didn't receive it, and I don't recall, so I'm giving you an address, but
You recognize that address?
which address?
Can you read that one more time, Ms. McDonald?
Yes, the address on January 27th that he requested discovery go out to was 600 Southwest Kenyon Street, apartment G201 in Seattle. The one prior to that he requested was 1005 North Cleveland Street, apartment C in Kennewick, Washington. All discovery was sent to both of those addresses.
Do you have the ability to get mail at the Kenyon Street address, Mr. Schuster?
No, I'm not sure why she sent that there.
Because that's the address you gave the court at the end of January.
Well, in January, the judge had denied subject matter jurisdiction, and so the matter should have been dismissed anyways.
So the judge denied your motion to dismiss for lack of subject matter jurisdiction. The court found that there is subject
She did.
matter.
It was on the record. She denied subject matter jurisdiction. She didn't deny my motion. That wasn't till.
She's being more than patient. Instead of simply moving on, she's taking a moment to reaffirm the denial so it's crystal clear. In other words, even though the court isn't obligated to revisit your recycled arguments, she has no hesitation in shutting them down again firmly, consistently, and on the record, if anything. This should be your cue to stop trying to relitigate the same failed motion and start participating in the actual hearing. But based on your track record, I'm not holding my breath.
Regardless, you did receive the two motions as well as the affidavit today. Is that correct, ma'am?
I did. Did Ms. McDonald? Have you gotten that yet?
I just
Perfect. Have
So,
you
Mr.
had a chance to read over that, miss?
So obviously, Ms. McDonald has not had a chance to read over it.
Oh, I was referring to
Provided
you,
her.
ma'am.
Okay, Mr. Schuster, let me talk. So do you remember doing the waiver of counsel on December 16th, where you said you wanted to go forward representing yourself?
Well, from the very beginning of this
Remember
matter,
signing this piece of paper saying you were representing yourself?
from the beginning.
That's not my question, Mr. Schuster.
I'm answering your question. I would like
I
to
don't want a
speak.
narrative. Yes or no?
Thank
Do you
you.
remember signing this piece of paper?
I don't recall.
Okay.
I
well,
don't know
your
what paper you're
signature is
showing me.
here on this piece of paper.
I'm not sure what paper you're showing me because
Okay.
it's very far from the camera and
So,
it's
Mr.
just
Schuster-
very hard to read because it's blurry
Okay.
from this
So
angle.
let me read it to you.
So I don't recall.
On December 16th, 2024, you went through a colloquy with Judge Grant. During that colloquy, you engaged in a series of questions about your familiarity with the rules of criminal procedure, criminal courts in general, the Constitution, and so on. At the end of that, you indicated that you have read and completed the form, you requested the court to allow you to represent yourself, and you signed it and dated it and noted you reserve all rights. On that form, one of the things that you are asked to do and acknowledge and understand is that you will be treated as though you are an attorney and you will be expected to follow the court rules as though you were an attorney. One of those rules that you're expected to follow is the Lake Forest Park Municipal Court local rules around how to file and the proper notice of filing motions. The local court rule requires that if it's a motion that is not set on the date of trial, that the expectation will be that you give 21 days notice and properly serve the other party. These motions dropped off, emailed, whatever to the court the day of and the day before the hearing are not properly noted under the local court rules. Nonetheless,
Well, this isn't
nonetheless, I am going to let you know that I have reviewed these motions. And if it's okay with you, Ms. McDonald, I'm going to go ahead and let Mr. Schuster know that I've reviewed these motions. There's two of them, a motion to dismiss for lack of subject matter jurisdiction, and another motion that is essentially a show cause motion for the prosecutor to appear and show cause as to why there is subject matter jurisdiction in this case. And what I want to tell you on the record right now is that Lake Forest Park Municipal Court is authorized to hear misdemeanor and gross misdemeanor cases along with violations of local ordinances. We are not authorized to hear federal matters. Your assertion that we are not authorized to hear federal matters is absolutely correct. Nonetheless, these are not federal matters. Federal courts do not have exclusive jurisdiction over travel and driving offenses. Proceeding with this case is not a due process violation of the Washington or the federal Constitution, and so I'm going to deny your motion to dismiss for lack of subject matter jurisdiction. Turning to your motion for show cause, you cite an RCW that outlines district court jurisdiction, which is not even applicable in this case, but nonetheless, Lake Forest Park Municipal Court is the correct venue for misdemeanor and gross misdemeanor driving offenses that occur in Lake Forest Park, Washington. The constitutional right to travel is not abridged by states and municipalities' adoption of regulations concerning driving privileges, and therefore I'm going to deny your motion for show cause against the prosecution. I'm also denying your motion to dismiss in that motion, finding that this court, again, does have subject matter jurisdiction in this case will proceed. So those
having so much confidence in the constitutional strength of your motion that you walk into court convinced you've outsmarted the entire legal system only for the judge to take one look at it and decide it so fundamentally incorrect that she can rule on it without needing a single word from the prosecution. That's not just a gentle hint that your argument is weak. That's a full-scale announcement that your filing is so far off base, it doesn't even require opposition. Moments like this really highlight the legal void that sovereign citizens manage to fall into. They convince themselves they've discovered some secret loophole or ancient constitutional truth, only to get smacked back into reality by a judge who doesn't even need a second opinion to dismiss it. When a court treats your motion as if the other side didn't need to show up at all, that should be a massive wake-up call, one that tells you loud and clear that you're operating in a completely different world from actual law.
Not really interested in hearing that you have yet a third new address for Ms. McDonald to send discovery to. So at this point,
It was never a third. In the beginning, you had the correct address. It's no longer the correct address.
Then it's
And
not the
so,
correct address. If it's no longer correct, then it's not correct. You've given a
well,
Kennewick
as of
address.
recent, as of literally not that long ago.
So
So,
when did the Kenyon Street address become a bad address?
I want to say within the last month-ish.
So sometime after January 27th, the Kenyon Street address became a bad address, correct?
And you said the motion to show cause was denied on what grounds?
It's not been properly filed. You did not comply with the court rules, but even allowing you to file and reviewing it, there's no basis for me to grant it. It is not legally sufficient to grant your motion.
To prove that you have subject matter jurisdiction?
So first of all, the prosecutor doesn't have to prove that the court has subject matter jurisdiction. I am ruling and telling you that this court does have subject matter jurisdiction for the reasons I previously stated.
And this is a court of record, correct?
Is a court of record.
You said this is a court of record?
It certainly is a court of record.
Ah, I see.
We are on the record now. So that being said, it sounds like Ms. McDonald has a plea offer to send you if you want to entertain that. Would you like her to send you that plea offer? And if so, what is the best way for her to do that?
Well, she's allowed to send me whatever she would like, but I do have an address since I want to make sure that, everybody has the correct information.
What is your current correct address?
The mailing address would be 2318 California Avenue. I believe that's Southwest. D?
Unit D?
I don't know how they label it, but it's just D is what I've seen. And then that's Seattle, Washington, 98116.
How do you live there but not know how they label it?
Oh, I didn't say I live there. I just get mail there.
Is that a friend's house? What is that?
Family.
What was that?
Family. And so, just so I'm clear, you're saying that the right to travel and privacy is not a federal matter, and that you're saying that you have the jurisdiction to hear a matter that involves this.
I am saying that there are federal constitutional rights, there are state constitutional rights. Sometimes one, sometimes both, sometimes none are implicated in a criminal case. I'm saying that the Lake Forest Park Municipal Court has jurisdiction over driving offenses that are misdemeanors and gross misdemeanors occurring in the city of Lake Forest Park, Washington, and that the fact that there are federal constitutional rights associated with travel does not preclude the city of Lake Forest Park from filing or prosecuting these cases.
Well, so the right to move freely, which is part of liberty and, a right, because no person shall be deprived of life, liberty, or property. You're saying that isn't a federal...
No, that isn't how it works, especially not in a basic municipal driving case. The authority for each state to create and enforce its own traffic laws comes directly from the 10th Amendment, which reserves powers to the states that aren't specifically delegated to the federal government. That means states have every right to regulate driving, licensing, registration, and anything else related to operating a motor vehicle on public roads, but many self-styled travelers latch on to the phrase life, liberty, or property as if it's some kind of magical loophole that exempts them from every statute they don't want to follow. They treat it like a universal get-out-of-responsibility card. believing that citing a few words from the Constitution suddenly overrides state law, municipal ordinances, and decades of established case law. In reality, that phrase has nothing to do with avoiding traffic regulations. It refers to due process, meaning the government must follow lawful procedures before taking away those rights. It doesn't mean you can ignore licensing requirements, skip registration, or declare yourself exempt from basic road rules. Courts have explained this countless times, but sovereign citizens continue to misinterpret it, acting as though quoting a single line transforms the entire legal landscape in their favor. Unfortunately for them, it doesn't work that way, and judges are very quick to remind them of that fact.
Jurisdiction that involved travel, and that the fact that there are federal rights around travel does not preclude Lake Forest Park Municipal Court from enforcing state and local ordinances. So what do you want to do on your case today, Mr. Schuster? Is it your intention to go to trial next week? Is it your intention to entertain a plea offer from Ms. McDonald?
Well, I just want the court to know that any judgment issued without proper subject matter jurisdiction is void and may be challenged at any time.
And you're free to
This
appeal
court
any ruling from
lacks
this
the
court.
authority to hear this case, and proceeding further would result in an unenforceable judgment. Therefore, this must be dismissed.
You are free to appeal any ruling this court makes. You can certainly, since you
Almost definitely.
how to do that. Nonetheless, we have to figure out what you're doing today on your case. It's your readiness hearing, where you tell us if you want to go to trial next week or if you want to entertain a plea offer from Ms. McDonald.
Well, as I've stated, this case should be moved to the proper courtroom, which it's not.
In the proper courtroom, and that's not happening. And Mr.
If it's not transferred, I do. It should be dismissed.
I'm not entertaining further motions to dismiss. Ms. McDonald, go ahead.
Yes, and Mr. Schuster, I sent to you in the chat because that is the only way for me to get that to you right now.
Oh no, you have my email. You got the information on the motions there. So you have the email listed above. I don't really know how to use Zoom like that, and so sending anything over through chat like this is just it's difficult. So email would be the best way if you want to get that to me faster. But of course, you have an address now that I'd be able to get the mail that you're saying you've sent already, but no worries. So
I'm using Zoom the same way we used it at the last hearing when we sent you documents and you were able to chat back and forth with me. So it's in that chat.
We didn't have a back and forth.
We did.
Chat. No, we didn't.
So there is a document in the chat for you to open and take a look at, and that is the city's plea offer. We are agreeing to dismiss 2 charges for a plea to 1 with a credit for time served recommendation. So if you'd like
as I stated, you can email it so that I can properly see it, because that's the best way for me to do it quickly, because I don't really know how to use this chat function in Zoom.
Ms. McDonald, do you have the ability to email it to him?
I'm looking for the email.
Yep, it's at the top for the motion to show cause, as well as the bottom of the motion for dismissal. But I can also just read it to you if you'd like that.
If you can put that into the chat so I can make sure that I don't spell it wrong, that would be great.
Well, as I've told you, I don't know how to use the chat.
So we're streaming live to YouTube, Mr. Schuster. Would you like to read your email for anyone who's watching YouTube to listen to and hear?
I mean, they can email me. I don't mind.
Then
yeah.
Spell out your email for Ms. McDonald.
Do you know how to spell my last name, Ms. McDonald?
Please just spell it out. Let's just be as clear as possible.
Well, it'd be my last name .jon@icloud.com.
Can you spell your last name for her?
Yeah. Are you ready, Ms. McDonald?
Yes, I am.
Okay. SCH.
Okay.
Can you hear me?
Yes, I can.
Oh, okay. I wasn't sure if you could hear me. I know we've had trouble communicating over Zoom because sometimes you can't hear. But SCH, USTER.
Okay.
You got that?
Yes.
Oh, okay. So
Is it-
my last name,
Uh-huh.
John, Jon.
Okay.
You got that?
Yes.
Oh, okay. At iCloud.com. And, it's actually pretty ironic that you say that about the email, but then mailing addresses are said out loud too. So that's just kind of ironic
So far,
that you would mention that.
yeah, well,
But
as I said at the beginning,
it's okay.
of court, everything's being broadcast on YouTube, but
Oh, I know.
now we
But
need to
nonetheless,
respond to the fact that you have changed your address repeatedly. So Ms.
nonetheless,
McDonald
that's
is
just
emailing you,
ironic.
Ms. McDonald is emailing you a copy of a plea offer.
Cool. You said you were going to send that in the mail as well. So, or
No,
information in the mail?
it's not coming in the mail. It's coming via email right now. You have the opportunity to
I'm
review
talking
it right
about
now.
the other information she was.
No, that's already been sent in the mail. You need to go to wherever those addresses were to get your discovery.
Mm.
The discovery was sent out on February 10th, approximately a week and a half after you gave that address on the record.
On the record, when the judge denied subject matter jurisdiction?
When you were in court on the record.
On that day, when she said she denied subject matter jurisdiction. Yes, I remember her denying subject matter jurisdiction.
You also gave an address. Ms. McDonald sent your discovery to that address about a week later.
So you're saying that you can't send that to the proper address, Ms. McDonald?
We've already sent it to both addresses that you've provided to the court.
What she's saying is you can't come to court once a month, change the address, have her send out discovery, and then come back a month later and say that wasn't the right address to send it to.
So you're not going to send it to the proper address.
All right. Well, if you would stop turning this entire process into a chaotic guessing game and simply provide the court with one clear, consistent address, you might actually receive the documents you keep complaining about. When you give multiple addresses, ignore official notices, or switch locations every few weeks, the court has no way of knowing where to send your paperwork. And when your mail bounces around like that, it's no surprise that your discovery never reaches you. If you genuinely want to defend yourself properly, the first step is cooperating with the very system you're standing in. That means choosing one address, sticking to it, and making sure the court and the prosecutor know where to send your filings. Once you do that, the discovery process becomes a lot smoother, and you finally get the information you need instead of spending half the hearing arguing over where your mail went.
Yes, it did.
So, Mr. Schuster, you should be receiving an email from Ms. McDonald. That is Ms. McDonald's plea offer. I'm going to ask that you review that and then let us know if you'd like to accept that today or if you'd like to move forward with trial.
Well, I'm on the Zoom right now.
Right.
And so my email, I'm using the same.
Camera and review your email.
What's that?
You can go off camera and review your email.
Okay, so I can just get off and then come back on?
I would prefer if you'd stay signed on to Zoom and just go off of camera and review your email.
Okay. Let me see if I can do this without getting off. Because as I've stated, I don't really know how to use Zoom like that.
If you get disconnected, you know how to get back on it.
Okay. One moment.
Can you mute yourself, Mr. Schuster, and turn your camera off to read your email?
Oh, I saw that Carmen had sent something over.
Yes, you need to open it and review it.
Oh, it says what you had said on the record, correct?
No, it's an entire form. It's about, see how many pages that is? About 8 pages.
Can you mute yourself and take yourself off video while you review that, Mr. Schuster?
I think so. Let me see if I can do this correctly. Oh, so I see everything that you've sent over. Obviously, I'd probably have to look at it longer to make sure I
I'm
read
asking
it
you to
carefully.
I'm asking you to do that now. We're going to go back on the record.
Oh, okay. It just might take some time. I mean, I've gotten through some of it, but for me to understand what's going on, I definitely would have to read it. I don't know if you have enough time for all of that, but if you do, I don't mind. Taking the time to fully get into it.
Ms. McDonald, you're on mute.
If he's asking for more time to go over the city's offer and to consider that, I don't have an objection to continuing the matter if he agrees to waive speedy trial.
Oh no.
Well, if you don't wish to waive speedy trial, then
Well, if she doesn't want to give me more time, then I guess we just got to.
Well, the problem is, Mr. Schuster, you have to be brought to trial within 90 days of your arraignment date. And so your trial is scheduled for next week, but if you want to take advantage of the city's
on
offer,
the 11th.
right, if you want to take advantage of
9 a.m.
if you want to take advantage of the city's offer and you want more time to review it, unfortunately, you would need to set over that trial date.
Well, I can counter to you right now if you'd like.
I'm happy to go in a breakout room.
I don't know what that means.
I don't know that these are necessarily conversations to have on the record, but
if you want to go into a breakout room, in other words, go into a separate Zoom room with just Ms. McDonald so you can discuss her offer, I'm happy to allow you to do that right now.
Okay, how does that work? How do we do that on Zoom?
I can do that. I can put you in a breakout room. You'll get an invitation.
Do I
Something
need it? Okay.
pop up on your screen for you to accept.
Okay, so just wait until something pops up.
Yep, I'm going to put you in there right now. It will be into room 1.
How would I come back though?
There will be a button on the bottom right that says leave breakout room and back to main session.
Okay, so it says join breakout room. Prosecutor McDonald is inviting you to join room 1. So I
Yes.
just click join?
Yes, and I'll be
Okay.
in there.
All right.
So the prosecutor and the individual from the city step into a private breakout room for a one-on-one discussion, away from all the noise and interruptions. Now, would it shock anyone that when they returned, the prosecutor announced that a competency evaluation might be necessary? Probably not. After everything we've seen so far, scattered arguments, misunderstood legal terms, repeated claims that make no procedural sense, it's honestly one of the more predictable outcomes. A competency hearing isn't something prosecutors request casually. It usually comes up when someone's behavior, reasoning, or communication is so disorganized that the court can't be confident the person understands what's happening or can meaningfully participate in their own defense. And judging by the performance leading up to this moment, it's not hard to see why. That option floated right to the top of the list. The prosecutor didn't come back with anything dramatic or unexpected. They came back with the logical next step. When the case is derailed by confusion at every turn, and considering the pattern we've been watching, it almost feels like this moment was inevitable.
Jonathan Schuster, 4A0525748. Mr. Schuster had an opportunity to speak with Ms. McDonald in the breakout room. And Ms. McDonald, where are we?
Yes, Your Honor. I'm a little bit concerned because it didn't appear that Mr. Schuster was, and I was kind of having a hard time discerning whether or not it was a willingness or an ability to track the conversation.
Oh, objection. I definitely have the ability to have a conversation and track what's going on. I offered her a counter and she didn't want to take it. And so that's where we are, ma'am.
So I do have some concerns there. Also, Your Honor, I did just pull up his criminal history. It appears that he does have an active warrant out for his arrest for a DUI.
Active warrant?
SMC bench warrant from 2/14/25.
Yes, that is the one. So I have a couple of concerns. The concern is the defendant is saying he doesn't have discovery. He has not read the reports. I asked him several times if he was prepared to proceed to trial on all 3 charges next week.
And I told her 9 o'clock on the 11th, I will be there.
So
mean,
Yeah.
Mr. Schuster, that you're intending to go to trial without?
Right. And you're saying there's an open warrant? Is that King County? Is that who that's with?
So, Mr. Schuster, the Seattle Municipal Court issued a bench warrant for $5,000 on February 14th, 2025.
Okay. And so I'll need to obviously reach out to them so that we can get that quashed and taken care of,
That is true. You will need to do that.
which I will do as soon as we're done here.
My expectation, if we're having another hearing next week, is that you will have done that before the next hearing.
Oh, 100%. No need to be walking around with warrants. That is unacceptable.
So, Ms. McDonald, are you raising 1077?
Well, I would ask that the court engage in a colloquy because like I said, I was having a difficult time assessing that because I don't know if it's an inability to
Objection.
practice
Objection.
appropriately or if it's
Nothing to
unwillingness.
So Ms. McDonald is asking that I ask you some questions to make sure you're able to proceed.
Objection, Your Honor.
Mr. Schuster, there's
I've
nothing
told-
to object
It's been
to.
on the record. I'm ready for whatever we need to do on the 11th outside of quashing this warrant that I just recently found out, as you said it. I didn't even know that was a thing. So now I have to just take care of that